Udell.
For the record, this matter is before the court for the purpose of reviewing plaintiff father's parenting time. This hearing is being conducted via Zoom. This is Tiffany Budell present on audio.
Yes, I am here, Your Honor.
Good morning. Is Robert Moss present on audio? It appears that he is not. Ms. Budell, have you had any recent contact with Mr. Moss?
Yes, Your Honor. On September 17th, I invited him to Chuck E. Cheese to see Shiloh on her birthday, to have some one-on-one time with her.
Did he attend?
Pardon?
Did he attend the birthday party?
Yes, it wasn't a party. I just, just her and him, Yes, he did. And then on September 24th, he wrote me a long message requesting to withdraw his rights and would I object. And then on September 29th, he wrote me another long message stating that he was going to file a motion to withdraw his rights. And then nothing since, Your Honor.
I'm sorry, I don't understand. What does he mean by a motion to withdraw his rights?
Correct, like withdraw his parental rights.
Okay. Well, he has rights and he has obligations as well. Is Mr. Moss still exercising supervised parenting time with Shiloh?
No, Your Honor. The supervised, the lady that was supervising terminated it, and she wrote a long letter, I guess, to the court explaining how I was very helpful and trying to get Shiloh to interact with her dad, but he wasn't focused on that. He was more so focused on downing me to her.
Okay. Right.
There should be a letter in the file, Your Honor.
There is no such letter in the file. Mr. Walker, has your office received communication? Have they terminated their supervision of the plaintiff father's rights?
Yes.
Supervised parenting time?
Supervised parenting, yes, Your Honor. We did receive a letter from Family Counseling and Shelter Services. Looks like it was received yesterday that did state that they were unable to continue with services for this case. Not because of either party doing anything wrong, but because the child would not cooperate and was unable. They were unable to get the child to spend time with dad.
This is a 1-year-old, pretty young child.
Yes, sir.
So there was not terminated because of father's failure to attend. Is that correct?
Correct.
That's odd. I was wondering if this recommendation, this order should reference that, but again, it's nothing certainly attributed to the conduct of the plaintiff father.
To be honest, my recommendation is mostly because father didn't appear today. Okay. And I don't know, without his input, I'm not sure where to go next as far as trying to get parenting time with him.
Certainly. Well, it's unfortunate Mr. Moss did not appear this morning. Thank you, Mr. Walker.
You're welcome, Your Honor.
This matter was scheduled for the record at 8:30. It's now 9:05. Mr. Moss has failed to appear. He was present on August 21st when this review hearing was scheduled. He's not appeared. So at this time, the court will enter an order suspending plaintiff father's parenting time until further order of the court. So Ms. Budell, obviously, Shiloh needs a father in her life. It's wonderful that the court applauds you for encouraging that, inviting him to the birthday party. To the extent that you can still reach out to Mr. Moss and encourage that, that would be in the best interest of your child, Shiloh. Okay.
Yes, Your Honor.
But at this point in time, he'll have to petition the court for parenting time, unless, of course, you permit it and allow it to be, and then maybe under supervision per your requirements. All right, that will conclude this hearing, Ms. Budell. You'll get a copy of this order. You can zoom out and have a good rest of the day.
Thank you for your time, Your Honor.
You're welcome.
Calling the matter of Stephen Lammy versus Echo Brook.
For the record, this matter is before the court for the purpose of reviewing plaintiff father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Russell Smith representing the plaintiff father, Stephen Lamming. Mr. Lamming is present. In addition, Echo Brook, are you present on audio?
Yes, Your Honor.
Good morning. Parties have conferred this morning with Ms. Brower from the front of the court as it was provided the court with a fine recommendation. That the parties are continuing to share joint legal custody of the minor child, McKenna. The physical custody is reserved. And Mr. Smith, Mr. Lamming, Ms. Brock, the court is of opinion that people make too much of an issue over physical custody. With joint legal custody, the two of you should share equally any major decision concerning the welfare of your child. So it's just a matter of parenting time. And the recommendation relative to parenting time is as follows. That father's parenting time shall be the first, second, fourth weekends of each month. Saturdays at 9 a.m. until Sunday at 7 p.m. Father shall have parenting time if there's a fifth weekend in the month. In addition, father shall have such additional parenting time as the parties can agree. In the event that the father's work schedule changes to first shift, father shall have parenting time 5 p.m. to 8 p.m. on Wednesdays. The front of the court holiday schedule shall be adopted absent agreement of the parties to the contrary. And that is the recommendation. Mr. Smith, is this recommendation agreeable with your client, Mr. Lamming, this morning?
It is, Judge. Unfortunately, we couldn't get any additional parenting time due to the fact that he works second shift and the child is school age. So we are in agreement with the recommendation. I appreciate Ms. Brower taking the time to fully vet this. This will work, and thankfully the parties are working together to facilitate my client's time with this child. So I think that's a very good sign for the future, Judge. So yes.
Wonderful. The court would agree, Mr. Smith, and obviously the two parents should be able to communicate, and if Mr. Lamming's work schedule changes, then obviously you have additional Wednesday, and then hopefully the parties can agree that the child deserves the most time with each parent as possible. Right, Ms. Bruck, do you understand the recommendation this morning?
I do.
Do you have an objection to the court adopting this recommendation?
I do not.
Right, wonderful. Mr. Smith, you wish to voir dire Mr. Lamming? He obviously participated in discussions, but if you wish to voir dire him, the court can have him sworn.
If I could just ask him one question, Judge, you don't need to swear him in.
Okay, go ahead, Mr. Smith.
Mr. Lamming, are you agreeable to the court's entry of the order that we discussed at the present time?
I didn't catch all that. Something else come above you, noise-wise.
Yeah, I heard that too. Are you in agreement that the judge enter this order today?
Yes.
Very good. I have no further questions, Your Honor. Thank you.
All right. Ms. Bruck, do you have any questions for the court?
I do not.
Okay. Obviously, as circumstances change, your work schedules change, and when Kenny gets older, we should always discuss modification of parenting time. Circumstances change, but the court finds this recommendation, which is agreed by the two parents, being the best interest of the minor child of McKenna. The court will currently adopt the agreement. All right, thank you, Mr. Smith, Mr. Lamming, Ms. Bruck, good job, and thank you, Ms. Brower. The court will adopt the recommendation. That will conclude this hearing. Now we can zoom out. Have a good rest of the day.
Thank you, Your
Thank
Honor.
you. You too.
Thank
Have a
you.
good day. Steve, I'll call you in about 10 minutes, okay?
Sounds great.
Thank you.
Thanks.
Burnett versus Christopher Ott.
For the record, this matter is before the court. The plaintiff's motion for to show cause, alleging violation of the mutual restraining order prohibiting, threatening, and harassing communication, as well as the plaintiff's motion to compel defense responses to discovery, as well as defendant's objection to a referee recommendation regarding issue of child support and issuance of a bench warrant. This hearing this morning is being conducted via Zoom. Present this morning is Attorney Timothy Churchill, representing the plaintiff, Catherine Ott. Ms. Ott is present with Mr. Churchill. In addition, Attorney Kira Demusis is present representing the defendant, Father Christopher Ott. Mr. Ott is present. Good morning, everyone. The parties have conferred at length with Mr. Pratt this morning before the court. Mr. Pratt is by the court find recommendations that Mr. Ott, court's awarded Dr. Moon is in the process of completing a psychological evaluation of Mr. Ott. Is that correct?
That is correct, Your Honor.
We don't have a written report yet, but Mr. Ott shall follow all his recommendations. So the show cause, plaintiff's motion or show cause is reserved pending that report from Dr. Wooten. Further, it's noted that the discovery responses have been sent But council believes the answers are not complete.
If I may, Your Honor.
Do we just set a review dates on these
We
issues?
provided as complete a responses as we possibly could. I would say the only response that might be amended would be the assets for my client's business. He is a self-employed, no appreciable resale market value. It would honestly cost him substantially more for me to prepare a response could possibly be worth on a resale market. Honestly, I mean, these are years old hand tools. He's already stated in the FOC hearing with Ms. Prod that he does not have any large machinery or, equipment that does have any income or, financial documents or records. He does not keep records. He does not have anything that brother counsel is seeking. I wish that there was something I could produce, but I've given him the responses that my client has attested to. I can't fabricate something that doesn't exist. And I have produced everything that does exist.
Right. Mr. Pratt, was there also discussion? I'm sorry, I do see a second order in the file.
There is, Your Honor. Yes,
Child support recommendation. It's recommended that the referee order of referee McKee be rescinded and canceled. And it makes reference to an enforcement order dated October 15, 2024. And does that provide for simply a continuation of the show cause? No bench warrants will issue. Is that correct, Mr. Pratt?
It does not, Your Honor. Friend of the court is requesting to proceed with contempt this morning on the show cause, on the child support show cause, Your Honor.
Okay.
We would ask that the court delay sentencing and allow my client the opportunity to make payment on the arrears. As far as how much, I think my client would have to provide testimony as to how much he would be able to pay at this time and how much time he would need to do so. But certainly, incarcerating my client would obviously not allow him to work to be able to earn money to pay any amount towards the arrears. That is counterintuitive to, his ability to improve this situation in any way.
The arrears are about $4,000. Is that correct?
$5,388.50, I believe, Your Honor.
Okay. Obviously, if Mr. I cannot afford the child support, then the court wants him to be proactive and file a motion to reduce support or modify support if that's what needs to be done. The court is not inclined to impose an immediate jail sentence, but simply wants Mr. Ott to move forward, whether it's filing a motion to reduce support or making more concerted effort toward reducing the arrearages. And Mr. Pratt, the enforcement order of October 15th, is that in the court file?
It is not, Your Honor, because again, I did not type it yet because we are asking that Mr. Ott be found in contempt. Mr. Ott stated that he has had income and he made payment in August, and before that, his last payment was February. So made a ruling on that. I did not type that out yet.
All right, thank you. All right, to Mr. Churchill, putting aside the issue of contempt at this point in time, it's recommended that your show cause action be reserved until we have that.
I guess, but I think it's clear what they're seeking is a free pass for his conduct until they get Luton's report. Basically, he's been intimidating family members, showed up at their house, engaged in all kinds of conduct violating that order. But because he has a mental health issue, they're asking for his conduct. And what Luton said is, I don't think is going to negate the things that he's done here. Clearly, the order said you're not supposed to threaten plaintiff's family members. He stalked these nasty emails he's sending her, calling a effing C, using that word 8-9 times in there. He's clearly violated the order, and I don't think Luton's going to say he doesn't know what he's saying when he does that stuff. He has a major temper problem, wants to put it off till we get the report. I guess I'm okay with that, but certainly we're supporting the contempt finding on support. August, according to his interrogatories, he has no idea what he's ever made. He keeps no records in his business. Wouldn't provide, he claims he's never got 1099s or K1s. This business that he claims he has isn't even in good standing with Laura. He hasn't filed an annual report since 2021. We don't have a clue what he makes. He won't disclose anything. I haven't filed a tax return in over 3 years. So guess what I'm making? We don't know. He told Stephanie he made $7,000 in the last 2 months. But what were your expenses? Well, I don't know. I don't keep track of that. I don't keep receipts. Do you cash check? Do you have a bank account? Nope, don't have a bank account. In 3 years and doesn't maintain any records. Things I've ever seen.
Right, thank you, Mr. Churchill.
When I'm done, you can address this. Objection, not reasonably calculated to lead to discoverable information. What did you earn the last 3 years? I'm not in possession of any of that information. On and on and on. We asked for federal tax returns. We did find out how can we figure the sport when he doesn't even know what he makes. Bank statements. Nope. Don't have any bank accounts. You keep any QuickBooks, anything like that? Nope.
Right. Thank you, Mr. Churchill. With respect to the conduct, obviously, Mr. Ought to shoot himself in the foot by plaintiff. The court would only hope that Ms. Attorney DeMusis can counsel Mr. Ott in that regard. And the court would likewise agree with Mr. DeMusis that perhaps Mr. Ott will follow the recommendation of Dr. Wooten, and Dr. Wooten's recommended course of action will assist him in maintaining control of his emotion. The court is inclined to follow the recommendation that the show cause filed by the plaintiff be reserved pending report from Dr. Wooten. Hopefully that will not himself in jail. With respect to the discovery responses, Mr. Musis, can you modify those?
There's nothing to clarify, Your Honor. That I don't know if I've ever seen a counsel so insensitive to mental health issues. My clients' mental health issues do not start and stop at, and mental health issues permeate almost every aspect of a person's life. And certainly how he conducts mental health issues. And the fact that he doesn't keep records, I'm sure, are impacted by his mental health issues. And my client may not, and Mr. Churchill's flippant attitude about my discovery responses and my client's behavior in this case demonstrate his insensitivity toward mental health issues, which I think is disgusting in this day and age. My client has undergone a very expansion in this case. He has undergone extensive supervised parenting time, see his children, and has jumped through nearly every hoop that this court has asked him to, all the while struggling with significant mental health issues. He has shot himself in the foot, and I have had extensive communication with him about that. And my hope here is that he is on the right track and that Dr. Wooten's recommendations will aid him in being on a better path moving forward. But I cannot clarify and provide better responses when my client does not have the records because he did not keep the records and communications prior to this hearing that he provided in the written discovery responses. So perhaps in the future, if his treatment course following Dr. Wooten's recommendations, maybe the future looks different than the past for him. But the past is what it is, and I can't change it. So Mr. Churchill and perhaps Ms. Kuhn may not like what the responses are, but they are what they are. And there are other for my client's financial records and income. And we've already addressed this. This is not day one of my client's lack of records or his self-employment. So the lack of information about his income has already been dealt with. And yes, there may need to be addressing whether or not child support needs to be modified going forward. That's a conversation for another day. But for today's purposes and the discovery issue, again, I can't do anything additional. I provided the signed authorization for release of medical records that they requested. It was for one medical provider. If there's something more that they want, they have to ask for it. There wasn't anything additional. And as far as the financial records, again, as far as I know, I've provided everything that they've asked for that I'm able to provide. I wish in tools, and the court is inclined to order us to provide it. I will certainly comply with court orders, but that would, again, I don't believe that would further any significant purpose in this case. It would cost my client significantly more than it would serve any purpose to Mr. Churchill or Ms. Ott in this matter.
All right.
He can be ordered to sell every tool and maybe come up with a couple $100. It's not going to put any money in that list.
We did ask for assets.
But there's no value there.
How much you paid in attorney
please,
fees.
Mr. Churchill, before we go any further, the court just realized yesterday, this court is at, I want to disclose this for the record, the court had a recent contact with Mr. Ott. The court owns a office building downtown Monroe. There's a crack in the building. I reached out to Ken Wickenheiser, who owns downtown properties, asking him for a recommendation as to a masonry worker to fix this crack in the building. Water's coming in, and he recommended Chris Ott. I met Chris Ott. I didn't realize until reviewing the file yesterday that this is the same Chris Ott that I recently had communication with. And I've not signed a contract with him, but he was going to repair the crack in the building. If in fact that's a conflict, arguably is a conflict, if you want the court to disqualify, we'll disqualify. In this case, go to Judge Lohmeyer. Mr. Churchill, I mean, this is a business, it's one-time business transaction.
I have no issue with that, Your Honor. I don't view that as a conflict. I mean, he's supposed to be working. We know he is working. He's just not paying his support. And one of the questions I just wanted to say, we asked counsel in the interrogatories was, how much has he paid in attorney fees? I'm willing to bet he's paid far more in attorney fees than he has child support.
All right, so do you want the court to disqualify
No.
Mr. Churchill? All right, the court's inclined to file a recommendation of Mr. Pratt in this regard, in terms of the show cause shall be reserved pending report from Dr. Wooten. The court understands plaintiff, and I don't know what to suggest. Maybe you can take Mr. Ott's deposition, but it sounds like he doesn't have a lot of records, not filing tax returns. In terms of, but the court will also file Mr. LaPre's recommendation that the court will commence contempt proceedings this morning. The intent of the court is to reserve any sentence, and I just wanted to get Mr. Ott to move forward in a responsible fashion. So, Mr. Musis, have you discussed with Mr. Ott the consequences of a contempt? If the court finds him in contempt, the court would order 45 days, but at this point in time, it's suspended. So, if the court would be giving him the key to the jail, he can avoid jail if he simply moves forward, whether it's filing motion to reduce support or start this. Have you discussed that with Mr. Ott?
Thank you. Yeah, but we will have that discussion after this hearing today.
Well, I need to know that now. Do you want to confer with Mr. Ott before we? Is he going to admit to contempt, or do you want testimony from the front of the court?
Testimony from front of the court.
Right, Mr. Pratt, we want Ms. Hicks to provide testimony, or can you provide testimony based upon the records of the front of the court?
I can provide testimony, Your Honor.
Right, right, Mr. Pratt, can you raise your right hand to be sworn, please? Ms. Pratt, are you familiar with the child support records in this case involving Catherine and Christopher Ott? And do the records reflect the current arrearage on the part of Mr. Ott? And what are the current arrearages?
The current arrears through the end of September were $4,587.50.
Because October technically is not due till the end of the month, is that correct? So
that is correct, Your Honor.
$5,000. And do the records reflect when Mr. Ott, what's his current monthly obligation?
$801 per month, Your Honor.
Mr. Ott made a payment in the month of August of 2024, is that correct?
Your Honor.
October?
August, I apologize, August, yes. February of 2024.
And what was how much was that payment?
$1,650.
Thank you. Mr. Musis, do you have any questions, Mr. Pratt?
No, I do not. Thank you, Your Honor.
In this matter, the court finds a child support obligation exists. Court further determines that there are arrearages, no testimony before the court. Strike that. The testimony is that Mr. Ott did make $1,000 payment in August of 2024, $1,650 in February of 2024, but nothing between the months of nothing was paid during the months of March, April, May, June, and July of 2024. There was no pending motion to modify support at this time. The court finds that based on these arrearages and the inconsistent payment history on the part of Mr. Ott that there's a basis for contempt. The court will currently find Mr. Ott to be in contempt of court for failure to pay child support as ordered. With respect to sentence, the court will order Mr. Ott for 45 days in jail, but will reserve that sentencing. So, Mr. Ott, the court's basically handing you the key to the jail. You got 45 days on your head. You can avoid one day if you simply be proactive and pay attention to this obligation. If, in fact, you can't afford the $800 a month, then you need to file a motion to modify support. So talk with Mr. Musis about that. Okay. Anything further this morning, Mr. Churchill, Mr. Musis?
Your Honor,
we set a review date. I'm sorry, parenting time is also before the court for review. Will parenting time continue? with Family Counseling Shelter
We're
Services?
waiting for the report of Dr. Wooten before we address that issue, Your Honor.
That's correct, Your Honor.
Well, parenting time was previously ordered for Family Counseling Shelter Services. Will that continue? in
It
the
will, Your
interim?
Honor.
Okay. Do we need to specify that in the recommendation, Mr. Pratt, that
We can add that, Your Honor.
parenting time will continue for Mr. Ott with the Family Counseling Shelter Services? Do we need to set a time frame? Mr. Musis, I'm trying to minimize the attorney fees and have to renotice something for hearing. Any idea from Dr. Wooten when his report will
It
be
should only
received?
be a few more weeks, but definitely before mid-December is what we've been told.
Why don't we set a review date? The review dates regarding these issues, not only the sport urges.
I think we have a review date in January, if I'm not mistaken, Your Honor.
Anybody know
I
what
do
that
see.
date is?
January 7th.
Okay.
Okay,
At
do you want to keep that
9:30
date
a.m.
on?
Yes,
You want to
please,
keep
Your
that
Honor.
date on then? All right, the court, I do note, I made my notes that there's a parenting time review. The one that was set for September 10th was adjourned by agreement to January 7th, 2025, 9:30 a.m. Mr. Churchill, are you aware of that? I believe Ms. Kuhn approved a stipulated order.
Yes.
So parenting time will continue. You put in this order, Mr. Pratt, just for the information to everyone that parenting time review continue to January 7th, 2025, 9:30 a.m.
Yes, Your Honor.
In a sense that might put it
And
all
then as
together.
far as the child support show
And perhaps
cause,
also-
could we adjourn that to November 19th at 10 a.m. on Ms. Hicks' docket, Your Honor?
It's fine.
To November 19th, you
available?
said? One
Yes.
moment. Let me just double check my availability.
That'll be on Ms.
I have
Hicks'
two
docket.
hearings that morning. I have 9 and 9:30.
Why don't we consolidate it on the 7th with the other issues?
Well, typically we don't let a show cause go for 3 months, Mr. Churchill.
Okay, probably not gonna matter in this case. He's going 8 months between payments. And he hadn't paid anything since August when he told you he made 7,000 in the last 2 months.
For that reason, we keep him on a shorter leash. We're not going to adjourn it out for 3 months. We're going to review it sooner than later, Mr. Churchill.
What about
Okay,
November
thank you.
12th?
I'm available that morning.
That'll be before front of the court attorney, Rebecca Hicks. And hopefully she'll not bring that before the court that day for imposition of sentence. Hopefully Mr. Al will make payments between now and then or take some affirmative action by filing motion to reduce support to do something.
What time would that be again?
10 a.m.
Okay. And will that be in person?
No, she does everything via Zoom.
Okay.
Do you want Ms. Hicks'
Yes,
Zoom ID
please.
number?
It's behind me, sorry. Thank you.
Your Honor, there was only one thing I wanted to get on the record from Stephanie. Subsequent to the payments being made in August, Mr. had indicated to her that he had earned approximately $7,000 in the last 2 months. And I didn't hear any testimony on current income from Stephanie that she obtained from Mr. Ott. In regard to the ability to pay issue here going forward.
Mr. Ott did state that gross income was $3,000 in August as well as $3,000 in September. His attorney asked what his expenses were and he was not able to answer that question.
And that he also sold equipment.
For
a bucket.
$800, a bucket that he sold for $800. That's correct.
Okay. And nothing was paid in since the 2 payments in August.
Correct.
I just wanted some testimony as an issue when we come
All right,
back, depending what Ms. Damascus does.
The Musis.
Do you want Mr. Ott sworn this morning? Do you want to take some testimony, Mr. Churchill?
No, I think what Stephanie testified to was accurate, correct, and I don't think it's being refuted.
Recitation of Mr.
Thank
Ott's
you.
testimony from earlier
The
is
court's
correct.
aware, Dr. Wooten, I'm sure his fees are significant.
They are indeed, Your Honor.
And it's an important expense so that we can address Mr. Ott's wellness. So anything further than this morning, Mr. Musis or Mr. Churchill?
No.
I have nothing further, Your Honor. Thank you.
Either
Okay.
here.
All right, that concludes here, and everyone can zoom out. Have a good rest of the morning.
Okay. Have a good day, everybody.
Thank you. You as well, Your Honor. Thank you, Ms. LeBron.
Thank you.
Yep.
Calling the matter of Jocelyn Belate versus Jalen Witherspoon.
For the record, this matter is before the court on the plaintiff's objection to a referee recommend order referring parenting time to the front of the court for formal investigation recommendation. This hearing is being conducted via Zoom. Is Jocelyn Belate present on Zoom? Oh, there she is.
Yeah, I'm present.
The plaintiff mother is present. Is Jalen Witherspoon present in audio? Mr. Witherspoon has not appeared. And Ms. Blade, you did mail a copy of this objection and notice of hearing to Mr. Witherspoon at the Prairie Circle address in Carlton. Is that correct?
Yeah, I actually have a video. The courthouse gave me an address, and I have a video of my friend putting the paper in his door in an envelope because they told me I'd have to pay a fee to get it notarized to prove it, and I didn't have the money to do that. So
Well,
I
you signed this. You certified that you mailed it, but you did not mail it.
Well, when I asked them about mailing it at the courthouse when they had me sign it, they told me that I could just take a video of me putting it, like taking it to his house, because I have no way, this has happened to me before where I didn't have no way to show that I did mail it and my hearing was canceled. So she told me if I just took a video of it, that would be okay.
Well, it's highly unusual. So what address, what home? So you were present and you took a video of your friend giving it to Mr. Witherspoon?
We put it in his door, like we slipped it in his door. I have a video of the paper and then I folded it up, put it in an envelope, took a video of the house with the address and then put it in his door.
Okay, and for the record, what was the address of the home?
It's 306.
Okay. Ms. Brower, is that the address that your office has on file for Mr. Witherspoon?
Yes, Your Honor.
And I did let her know too that on the paperwork, I found Jalen's phone number and I've texted him twice while waiting, so.
Any response? And not real impressed with your level of service. You signed a document indicating you mailed it to him, Ms. Vlade, and you did not mail it to him, so your proof of service is questionable, but the court's going to adopt the recommendation. So you'll both be sent to be contacted by the front of the court on a recommendation. You can state your opinion that your daughter or child does not know her dad. We'll see whether Mr. Witherspoon responds. If he doesn't respond, then it's not an issue. But your child has a right to have a relationship with her father, even though it would be perhaps supervised parenting time initially to develop that relationship. It's not going to happen overnight. He's got to crawl before he starts walking. So we're just delaying the inevitable.
But Jalen was in prison for a year. In the 3 years before that, he did nothing for my kid. He's never been around her. He does not care.
Okay. Well, obviously he filed a motion for parenting time, so obviously there must be some interest in his part. So we'll refer to the front of the court, have him do a formal investigation recommendation. It's not an order. It's got to come before the court. And when you get the recommendation, you can file an objection. The recommendation will come back before the court before there's any parenting time. So we're just taking one small step forward, Ms. Blade. So again, at this point in time, Ms. Brown, the court will adopt the recommendation simply to refer the matter to the front of the court for formal investigation recommendation. We'll see whether or not Mr. Witherspoon responds and cooperates. If not, then so be it. So we'll take one small step at a time.
And then if he does though, then he just gets to see a kid that, what about his other two kids? Like, that's what I'm saying. I think this is so unnecessary that it's just my kid when he has two other kids he hasn't seen in 7 years. This isn't anything new.
This court's not concerned about the two other children. The court's only concerned about the child born to you and Mr. Witherspoon. So we'll see whether he responds. If he doesn't, then it's a moot point.
And then if he does respond, then what?
The front of the court will communicate, will contact him for some input on parenting time. If he does not respond, then the recommendation is that his parenting time be suspended. Continue to be suspended. So we'll take one step at a time. So Mr. Brown, modified recommendation. You'll be mailed a copy of this recommendation. All the court's doing this morning, Ms. Flade is adopting the recommendation that the front of the court conduct a parenting time. Just a parenting time recommendation, not custody, just simply parenting time.
So if he responds to it, then he just gets parenting time? He just gets to see my daughter?
Nope, he's got to come back before the court. And you'll have a chance to express your input at that time. You can remind the court he has nothing to do with his two other children. He doesn't know this child. He's had opportunities to do so. He's not, for whatever reason, I know he's been in prison. I don't know how many years he's been in prison. This is a 4-year-old child, correct?
She's going to be 5.
Okay, so we'll see what, we'll see whether he responds. If he responds, then you come back before the court and express your concern. The court would most likely, if the court's going to permit parenting time, if he responds, it'd be supervised by Family Council Child Services. So he'd perhaps be able to see the child once every 2 weeks or something to develop that relationship. So take one small step at a time, Ms. Blade.
But I
Will
just
you be
feel like
held
if that's something that he would have done it 4 years ago, he would have done it 3 years ago, he would have done it 2 years ago, he would have done it when he got out of prison. He's been out of prison for almost over a year.
Yeah, maybe he's gotten his act together. I don't know, Ms. Valeda, I don't know why he delayed, but he did file a motion for parenting time. So obviously he seems to have an interest in develop a relationship with the child. And he references that in his motion. So we'll see whether he responds to the next step. The court understands your position. That will conclude this hearing. You can zoom out, and I'm sure we'll see you again soon.
How am I going to get the information about court?
I'm sorry?
How
You'll be
am
mailed
I
a
gonna
copy of this
receive-
order.
Huh?
You'll be mailed a copy of this order.
Okay.
Okay?
Good morning, Mr. Longton.
Judge, that new
Well, Mr. Lawson,
recommendation
haven't
is
seen you in a while.
Yes, Your Honor, you're looking well.
Not as young as you.
Well, I just had a birthday this week.
Well, happy birthday.
Thank you. Number 78.
Okay, that's wonderful. This is my last term. I'm up on the ballot this fall. Of course, I'm 68, and of course, you can't run after age 70. But I still enjoy what I'm doing. So I can be on the bench till I'm 74, and then I'm sure I'll probably go back into private practice after that.
Well, in all honesty, if you were willing to be a visiting judge in Wayne County, they'd have you employed full time.
But then unless I can do it by Zoom, I don't think I want to drive to Detroit.
I understand that too.
Is Wayne County, are they changing things? Are they, particularly family court, are they having more in-person hearings in family court?
No, 95% is still Zoom. I've only been downtown twice this year and they were for trials, but everything else is Zoom.
Okay, so I know some courts are going back to in-person. I think the Zoom is ideal for family court docket, and the practitioners down here seem to like it. Now, if I have an evidentiary hearing, I'll do that in person, but the motion hearings, pre-trials, I do by Zoom.
Oh, I agree with you. I don't think anything is lost by doing it by Zoom.
Good morning. Are you William Vine?
Yes, I am. Good morning.
Is
You guys
your
hear me?
attorney, Steve Rotenberg, going to be here today?
He's supposed to be. I talked to him. He called me last night, ma'am.
Okay.
Very good. We'll wait on him. Thank you.
Okay. I wasn't supposed to get anything in the mail, was I?
You can talk to your attorney about that, but this
Oh,
is
no, I
Mr.
didn't know.
Longton's.
Right. I didn't know if I was supposed to get anything in the mail. I got something originally, so I wasn't sure. But he called me last night at 10 after 4 and let me know about today, the rescheduled time.
That's okay.
We need to break our room till Mr. Rotenberg appears. Hopefully it'll be soon.
Yes.
Okay.
Derica Banks versus William Sanders.
For the record, this matters before the court on the plaintiff mother's objection to a referee recommended order, which denied her motion to change domicile of the minor child of the parties from Michigan to Missouri. It appears that this hearing is being conducted via Zoom. Both parties will be present. You are Derica Banks, is that correct, ma'am?
Correct.
And sir, you are William Sanders?
Correct.
You met with Mr. Pratt this morning, who has provided the court the following recommendation. The recommendation is that the referee recommend order be adopted, but modified, and that the issue of custody and parenting time be referred to the front of the court for a recommendation regarding custody and parenting time, and giving each party 21 days in which to object to any recommendation. So the front of the court will contact both of you to discuss custody and parenting time. They will make a formal recommendation to the court. You'll both get a copy of it, and both of you have 21 days in which to file a written objection. If you file a written objection, will come back before this court for final determination and hearing. If you're agreeable with the recommendation, no need to do anything. It'll become an order of the court automatically upon the expiration of 21 days from mailing. That's recommendation. Ms. Banks, do you understand the recommendation this morning?
Yes.
Okay. Mr. Sanders, Ms. Banks, do you have any objection to the court adopting this recommendation?
No, not at the moment.
All right, Mr. Sanders, do you understand the recommendation and do you have any objection?
I understand and no, I do not have any objections.
I'm sorry, you have no objection?
Correct, no objections.
Okay. 5-year-old child is in preschool. Is he in preschool in Missouri or here in Michigan?
He's in kindergarten here in Michigan.
Okay. So that will continue. You understand that, Ms. Banks? So until we address this matter further when the front of the court does their investigation.
Yes,
I understand. What about parenting time for Ms. Banks in the meantime? Is Ms. Banks able to come to Michigan for parenting time?
Your Honor, I have no objection to her seeing him at all, but Your Honor, she hasn't been here in Michigan to visit him since she left except for the times we had court here with referee McKee.
Okay. Obviously, why don't you try two of you talk about doing some Zoom or some FaceTime with your child so that your child can see mom, talk with her. So why don't you talk about maybe some evenings, a couple days a week where you can do a regular FaceTime with mom.
Your Honor, I bought him an iPad and she can FaceTime him whenever she like.
Okay, good. That's important.
But but he's been telling me she hasn't been calling him lately.
I call him every other day.
And I don't mind it. Like I completely gave ownership to my son in regards to his iPad. I don't use it or anything. It's solely for him.
Well, try to make it work, Mr. Sanders. It's in your child's best interest to have a relationship with mom. So to the extent that you can make that happen, you are benefiting the best interest of your child. So the court will strongly encourage that. At this point in time, being no objection, the court will adopt the recommendation this morning that the referee recommended be adopted. Mom's motion to change domicile is denied at this time, and the issues of custody and parenting time will be referred to the front of the court for a formal investigation and recommendation. You both received a copy of that. Is there any other questions, Ms. Banks or Mr. Sanders?
No.
Okay, now close this matter. Zoom out and
I do have a
facilitate
question.
FaceTime as much as possible.
Your Honor, yes, I don't hinder him from doing that at all.
I'm sorry?
Or I'm sorry, I don't prevent him from doing any of that at all with her. And she's aware of that.
Okay, that's noted.
But I do, Your Honor, I do have one question.
Go ahead.
I don't know about this process. But I do, so my concern is I want to know how long it will take for an actual decision to be made by the courts.
Well, the front of the court probably have 45 to 60 days in which to complete their investigation recommendation. And then you each have 15 days, 21 days thereafter in which to file an objection.
Okay.
So things will stay as they are right now, pending any further action by this court.
Yes, and I have considering the current order, which is joint physical custody, it's kind of impossible. It's kind of impossible for me to get down there every 2 days to get the car. So with me video calling him every other day, is that okay for right now?
Absolutely, that's what the court's encouraging.
Okay.
Try to do it at least a couple of times a week.
Yes, I make sure I do that. Sometimes he's, busy, he don't answer, but I make sure I call my baby every.
Well, yeah, the two of you should talk about your work schedules. What's a good time for the child? Maybe after the dinner hour, maybe 7 o'clock every evening.
Yes. Okay. Yeah.
All right. So please work together it's benefiting that child. All right. With that, you can both zoom out. Have a good rest of the day.
You too, Your Honor.
Welcome.
On the matter of Taryn Minton versus Jeremy Cash.
For the record, this matter is before the court on the plaintiff's motion for temporary child support. This recently filed the support action. Present is this hearing is being conducted via Zoom. Present is Attorney Carmen Moyer representing the plaintiff mother, Taryn Minton. Ms. Minton appears to be present with Ms. Moyer. In addition, Attorney Matthew Vido is present representing the defendant, Jeremy Cash, and Mr. Cash is present with Mr. Vido. Good morning, everyone.
Good morning.
The court has received fine recommendation from Mr. Pratt. The recommendation is that the party shall share joint legal custody of the minor child on a temporary basis without prejudice. Neither party shall consume alcohol immediately before or during parenting time. Minor child shall not enter any rooms that are being renovated in father's home. Father should make sure that the baby gates he has ordered are installed as soon as he gets them. Father shall have parenting time with minor child every other Saturday and Sunday, 9 a.m. to 6 p.m. commencing November 1st, 2024, as long as SoberLink has started. SoberLink is not in place by November 1st, and parenting time shall commence the Friday after SoberLink is in place. With respect to child support, commencing November 1st, 2024, the defendant father shall pay child support in the amount of $1,496, $1,496 per month. Uninsured medical expenses shall be shared as follows: plaintiff mother paying 42%, defendant father paying 58%. It's based upon mother having 290 overnights, defendant father having 75 overnights, which of course can change. Further, that it's ordered that the father shall use SoberLink starting as soon as possible. He shall use the device every day for 30 days in a row at 12 noon, 6 p.m. and 10 p.m. Further, the party shall mediate with Josh Walker on November 20, 2024 at 1:30 p.m. A motion hearing scheduled for October 30th at 1:15 is rescheduled to November 20th, 2024, subsequent to mediation. This court will not be available on the afternoon of November 20th, so we cannot, the court cannot schedule motion hearing. We can do it at 1:15. Court needs to be out here at 2:30, Mr. Walker. So we're gonna, this motion hearing we're gonna address before mediation. Is that the understanding?
Your Honor, we can adjourn that to the next available date that the court does have available for that pretrial on my motion. That way we can mediate that day. And,
so the mediation is good for November 20th, and you want to put a review hearing or pretrial thereafter?
yes.
Just be a review hearing, because obviously with this order, if it's adopted, that will stop the court's clock. This being a support action, we've got a support order being entered, so that will stop that. Do we need a review date, Mr. Vidal? If there's some cannot be addressed, can someone simply?
Just keeping it on the court's calendar, Your Honor, is something I think is helpful to help the parties reach an agreement.
Right. So you want to reschedule the October 30th motion hearing, correct?
Yes, Your Honor, just to accommodate mediation.
Okay, so let's see what's we have available after October 30th. About the first week of November, 5th or 6th. How about the first week of November, the 5th or 6th on our Tuesday or Wednesday docket?
Well, I think we wanted to mediate first.
That's correct. Right, the mediation. Oh, I see. Okay, do you want this? I'm sorry. That's right. After November 20th. So the 26th or 27th.
Are you going away for Thanksgiving? Okay.
What he's pushing it? Nothing in the morning. Much prefer the mornings.
The 26th would work.
Okay, about the morning, the court prefer the morning of the 26th or 27th.
Your Honor, do you have anything available before that week?
Well, you wanted after mediation, correct? Mediation is November 20th.
Oh, that's right.
Yeah.
That's right.
26th or 27th.
You're out of town.
Mr. Cashwell will be out of town.
He's going to be in the UP with probably no service, Your Honor.
Okay.
On the 26th as well?
Yeah, he's gone for a 10-day period.
Oh, he's hunting.
How about December 3rd or 4th?
December 3rd would
We'll
work.
make that work, Your Honor.
Yes.
December 3rd works best for my client.
The 3rd works for me too, Your Honor.
Okay.
10 o'clock.
That's fine.
Yes, thank you.
All right, thank you, Mr. Walker. If you could indicate, we'll keep the mediation date of November 20th at 1:30. That the motion hearing scheduled for October 30th, 1:15 is rescheduled to December 3rd at 10 a.m. You can just change that last part of that last sentence, please.
Yes, sir.
Thank you. All right, Ms. Moyer, does your client have any objection to the court adopting the recommendation that the court recited?
There was one thing that I don't believe we agreed upon, which is the shared joint legal custody. I thought we were going to address that on the 20th and just leave it as addressing parenting time and support for now.
That's correct.
Your Honor, when I wrote up the recommendation, I put temporary and without prejudice up in that.
Yeah, so it
Parties
does
did
say
not
temporary
talk
without
about
prejudice.
Parties did not agree to any type of custody arrangement at this time.
Right, but any objection, Ms. Booker, what's your client's objection to a temporary joint legal? If a child needs elective surgery, shouldn't dad be consulted?
Well, Your Honor, we're going to open a can of worms here because part of the reason, and I want to say Mr. Walker and everybody did a great job today. Part of the reason we're doing what we're doing today is that there are some factual issues in dispute that impact both custody and parenting time. And my client is not comfortable agreeing on even shared joint legal custody at this point. The parties live together. The child is now residing with her full time. It's a 2.5-year-old child. Dad's got some issues that he's willing to address, and we're just going to kind of see how it goes.
All right, I understand that. So Mr. Walker will just delete that reference to, we want to address custody, and this time you can just delete that reference to temporary without prejudice. So the court will simply, that's all that's been requested in plaintiff's motion. So for child support, we have some parenting time and sober link. So we'll just delete any reference to custody then, Ms. Moyer. Mr. Vitado, with the remainder of the recommendations agreeable though, Ms. Moyer, is that correct?
Yes.
Yes, I think that was the only issue that the parties, everything else is what they agreed to, Your Honor.
Right. All right. Both parties did participate in the discussions with Mr. Walker. Do counsel wish to voir dire your respective clients regarding this recommendation?
Yes, thank you, Your Honor.
Do you want the parties sworn, Ms. Moyer?
Yes, please.
Right, Ms. Minton, Mr.
You have
Cash?
to speak a little louder.
Yes.
Yes.
Thank you. All right, Ms. Moyer.
Yes. Ms. Minton, can you just state your full name for the record and spell it?
Taryn Janelle Minton, T as in Tom, ARYN, JANELMINTON.
And you are the plaintiff in this matter?
Correct.
And did you hear the agreement that the judge placed on the record?
Yes.
And do you feel like you had a full and fair opportunity to participate in mediation with Mr. Walker today?
Yes.
Do you have any questions about the agreement?
No.
And do you feel like you're freely and voluntarily entering into this temporary agreement for now?
Yes.
And for now, do you believe it to be in the best interest of your daughter?
Yes.
Nothing further.
Thank you, Ms. Moyer. Mr. Vitto, do you have any questions, first of all, for Ms. Minton?
I do not.
Questions for Mr. Cash, please.
Thank you, Your Honor. Mr. Cash, would you say and spell your name for the record?
Yes, Jeremy Odell Cash, ODELLCASH.
Thank you. And you've heard the agreement was placed on the record?
Correct.
You understand that this is temporary and without prejudice?
Yes.
It means it's leaving it open for discussion in the future at mediation.
Correct.
Okay, and on a temporary basis, do you believe this is in the best interest of your daughter?
Correct.
Okay, and no one's forced you or promised you anything to get you to enter into this temporary agreement?
No, sir.
Okay, and you want the court to adopt it?
Yes.
And you understand if we had a hearing today, we would have only been hearing the child support issue. But the child support on a temporary basis, you believe that's also in your child's best interest?
Yes.
Okay. No further questions, Your Honor.
Thank you, Mr. Vitto. Ms. Moyer, do you have any questions of Mr. Cash?
I do not.
All right, thank you. Just to make sure we're on the same page, the recommendation follows shall have parenting time every other Saturday and Sunday from 9 to 6. Does that mean Saturday one weekend, Sunday the next? Or is it alternating weekends of Saturday and Sunday, the 2 consecutive days?
The 2 consecutive days.
That's correct.
And that will start November 1st. So November 1st, that's a Friday. Actually, will start November 2nd, as long as SoberLink has been set up by then. And Mr. Cash will have November 2nd and 3rd from 9 a.m. to 6. And then the same 2 weeks thereafter, correct?
Yes.
That's correct.
All right, just want to make sure we're on the same page. Hopefully that SoberLink will be in place by November 2nd. All right, with that, we'll modify the recommendation and we will have a review of these issues December 3rd at 10 a.m. After the parties will meet with Mr. Walker on November 20th at 1:30 and the motion hearing date of October 30th at 1:15. Again, that's being adjourned to December 3rd, 10 a.m. All right, that will conclude this matter. We can zoom out and have a good rest of the morning.
Thank you, Your Honor.
Mr. Walker. Ms. Moyer,
Thank
Mr.
you,
Bill,
Your
thank
Honor.
you.
Thank you, Josh.
Thanks, Josh.
Calling the matter, Catherine Vine.
Have a
versus
good day.
William Vine.
For the record, this matter is before the court on the plaintiff's motion for temporary relief. This hearing is being conducted via Zoom. President Attorney Paul Longton, representing the plaintiff moving party, Catherine Vine. Ms. Vine is present with Mr. Longton. In addition, Attorney Steve Rotenberg is present, representing the defendant, William Vine. Mr. Vine is present. Good morning, everyone.
Morning.
Good morning.
Have the parties have conferred with Ms. Patrick this morning from the front of the court. Is that correct?
That's
Yes,
correct,
sir.
Your Honor. Plaintiff is moving to dismiss her motion.
Dismiss or simply adjourn without date?
Well, I'm moving to dismiss it. We have a status quo order, so I'm going to take a different route as far as getting her money. As far as the motion concerned, for spousal, we'll dismiss it, and I'll deal with the show cause order separately.
Well, we can address that today. Are the marital bills, is the mortgage payments being made, and insurance and so forth?
Yes, Your Honor. You have a status quo order requiring him to use his money to pay bills. I submitted a monthly statement to the front of the court showing mom spending $5,300 a month. Dad moved out. He's been gone August, gone September. He has one personal bill for $350 a month he's paid, but he's paid none of these other bills. They total $53.96. I don't know if Your Honor has an image of her monthly bill statement or not.
I do, but let's address that this morning. It's all part of your motion for a temporary order. The court was inclined to suggest, unless the parties reconciled, let's schedule us for mediation. It's a DO case. We have a shorter time frame for the court to adjudicate this case. Any reason why we can't schedule us for mediation?
We have no objection to mediation. However, we do object to some of the charges they have that they seem excessive. My client says they're excessive. He doesn't, and when he moved out of the house, he was basically told he was thrown out.
Mr. Rotenberg.
Yes.
It needs to be addressed at mediation.
Yes.
Okay, we don't need to argue about it this morning. All right, so Mr. Longton, any objection to schedule us for mediation with a pretrial to follow?
I don't, Your Honor, but after this morning's experience, I'm guessing mediation is not going to have much of a chance of success, but I'm not against it. We've discussed Mr. Godfrey as a mediator.
Well, Mr. Godfrey is going to be about 3 or 4 months out. So that's fine. I said if you want to do that, the court's going to take the proofs this morning. And then we'll set a pretrial conference maybe after the first of the year, because I don't think you're getting to Godfrey before the end of the year.
Okay.
Well, we can pick another mediator, I'm sure.
Well, Attorney Spiros, Michael Spiros also is available for mediation. Ms. Patrick is very capable.
I would object to Spiros at the moment because I've got a bunch of cases in front of him and I've had problems with
I'm not going to order any private mediator unless the parties can agree.
Yeah. As an individual, I've got no problem with him.
Okay, so Mr. Longton, obviously, Mr. Patrick has a little bit of experience behind her as well. But if you want Attorney Godfrey, that's fine. You should probably reach out to him today because, like I say, he's backed up for months.
Well, let's go with Mr. Godfrey. He can. I'm sure he has cancellations like every other meeting.
Okay. Yeah. Any objection to court taking the proofs this morning to establish jurisdiction as a breakdown that your client's not now pregnant? The court will simply reserve all standing issues. Is that agreeable?
Yes, Your Honor.
Yes, Judge.
All right, Mr. and Mrs. Vine, can you both please raise your right hand to be sworn, please? All right, Mr. Longton, if you can please secure the statutory proofs from Ms. Vine, please.
Sure. Ma'am, when you filed the complaint for divorce, had you been a resident of the state of Michigan for at least 180 days and of Monroe County for at least 10 days?
Yes.
And there were two boys born to this marriage, correct?
Correct.
And they're now in their 20s, correct?
Correct.
You're not presently pregnant, correct?
Correct.
Is there any chance of reconciliation?
No.
Have the oxygen of matrimony been destroyed?
Correct.
Your Honor?
Mr. Rotenberg, do you have any questions of Ms. Vine?
Just the crazy statutory one. Ms. Vine, are you pregnant?
No.
Okay, thank you. I apologize for having to ask that, but that's required.
Any questions for Mr. Vine?
Yes, Mr. Vine.
Yes.
Prior to filing of the divorce, were you a resident of Michigan for 180 days and of Monroe County for 10 days prior?
Yes, I was.
And is everything that you said in that complaint or your counter complaint accurate then?
It is accurate.
And is it still accurate?
It is still accurate.
Has there been a breakdown of the marital relationship?
Yes, 100%.
Is there any hope for reconciliation?
There is zero hope.
Okay, no further questions.
Based upon the testimony that's been presented this morning, as well as the complaint filed in this matter, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. At this point in time, the court will simply reserve all outstanding issues, pending mediation with a private mediator to be agreed upon by the parties. Mr. Rosenberg, do you have any objection to Godfrey?
No. No
Okay.
objections at all.
Mr. Longton, so you'll reach out to Godfrey?
I will.
I would suggest this morning, his number is 242-3434, area code 734. So the court suggests you reach out to him as soon as possible, get some dates and times, and forward those to Mr. Rosenberg for his review. Is there any need to schedule a pretrial at this point in time, or do you want to simply notify the court? Maybe Mr. Longton, once you've agreed upon mediation date, maybe let the court know, Miss Nancy from my office, and we can schedule, we'll send out a pretrial notice to immediately follow that mediation so that the court's available.
That works, Your Honor.
Yeah, that would work too, Judge.
All right, that will conclude this matter. You can all zoom out. Have a good rest of the morning.
Thanks.
Thank you, Ms. Patrick.